For the month of May, I will read the appeal statement. Pursuant to Section 2.68.030 of the Metropolitan Code of Laws, please take notice that decisions of the Community Oversight Board may be appealed to the Chancery Court of Davidson County for review under a common law writ. Any appeal must be filed within 60 days after entry of a final decision by the board. Any person or entity considering an appeal should consult with an attorney to ensure that time and procedural requirements are met. I see that we do not have a quorum. Is that right, Mr. Secretary?
That is correct.
All right. So at this time, it will be information only that we are providing, and we will now move to the chair remarks. The past few months have been extremely challenging for Nashvillians as we navigate what everyday life will look like and feel like, as our voting rights as Nashville-Davidson County citizens have been met with fierce opposition from the state legislature and have essentially been trampled on pertaining to city government. The attempt to reduce our local government of council members from 40 representatives to 20, and now the bill which has recently signed into law by Governor Bill Lee that preempts Metro Nashville community oversight, restricting us, limiting us from creating a robust community police oversight committee that would usher in a more fair and just, transparent relationship which has been long overdue. A bill that wishes to set back police and community relations, particularly what Nashvillians had in mind in 2018 when 135,000 voters, Democrats, Republicans, and others went to the polls and made their voices heard. The Community Oversight Board was birthed following the shooting deaths of Jacquees Clemens and Daniel Hambrick by police. And since its inception, the COB has created 22 policy recommendations that have been implemented by the Metropolitan Nashville Police Department and received more than 200 complaints from residents, indicating the work is not done. Police and community relations is a journey, given our history. And the COB is still committed to building, maintaining, and shaping a robust public safety agenda that will help build trust in law enforcement in our city and county. But the work must continue. We must march forward and build a community where everyone can breathe. With that said, the General Assembly took their best shot at us, but we are still here. The COB still exists, and we will not abandon a community who said they wanted a place for their voices to be heard. It's now incumbent upon Metro Council, the mayor's administration, Metro Legal, and ultimately the people of Nashville to protect community oversight of police. By passing an ordinance that reestablishes a community oversight agency as a permanent part of metropolitan government. We have some deadlines ahead of us. July 1 is the deadline for our budget, and council will be proposing an ordinance that constitutes a community review board that has the ability to, number one, ask Metro Council to issue subpoenas on our behalf, protect a majority community organization and council nominated process, and fully fund a community oversight agency so that it does not get reduced or relegated to symbolic or in-name only authority to oversee police, and to properly oversee the police in matters of misconduct. To do that, you need staff, and you need money. The charter referendum specifically named a minimum budget to ensure that the agency would be able to have the resources necessary to do what was asked of it. The new ordinance replicates that budget request. Finally, we have a short time frame in which to pass the ordinance. The ordinance is expected to be filed by Friday, May 26th. To get it passed by July 1, it will take 3 readings with 2 separate votes and a 2/3 majority of council. June 6th, June 13th, and June 20th. One of those votes, June 13th, will need a special request and approval by the Vice Mayor's office. Now is the time. Now is the time, Nashville, to get in touch with your council members. Now is the time to help protect and reestablish a community oversight agency in Nashville. We have the power. We can do it. Thank you. That concludes our chair remarks. We will now move on to discussion items. Go ahead.
I'm not sure I asked the legal advisor, is a quorum a majority of the full 11 board members, or is it a majority of those that are seated, because that number changed today?
Correct. So we need a majority of 10, which would need 6.
5 didn't do it?
I don't believe so.
Okay, just wanted to check. Thought we might be in session.
Yes, sir.
So,
According to the bylaws, 6 would be a quorum.
yes. And so while I still have the floor, we will go ahead and address Secretary Goddard that the chair of the Community Oversight Board did resign from the chair's position. And so we will have further discussion on that. Just wanted to make everyone aware of that.
I wasn't trying to force the issue, just trying to do the
It's
math.
okay.
Thank
That's
you.
all right. Thank you. We'll now move on to the legislative update. Attorney Yoon.
Thank you, Chair. As you know, last Wednesday, the 17th, Governor Lee did sign it into public law. I don't have the chapter and number yet, but once I do, I can update the board. In response to that, or in further work that our staff has been doing since January when we first became aware of this pending legislation, we have hired the legal services of one of the best attorneys in Tennessee. We have at our disposal, thank goodness, Tricia Hertzfeld, the former ACLU legal director for many years, a former public defender in Miami, doing multiple dozens of high-profile cases and trials with the offices of Elliott Osment, an immigration firm here in Nashville based. So thank you for being here tonight and for lending us your services, and I'll turn it over to you.
Well, thank you for having me. That was quite the introduction. I'm going to let Daniel introduce me everywhere I go from here on out, and I'll try not to blush too much. As Daniel said, the governor signed the legislation to change the way community oversight is done in this state, and I think that's probably a neutral way of saying it. We are looking at that legislation and considering our various options about how to move forward and what the legislation that's introduced to the Metro Council will look like and what that timeline looks like. As you all may be aware, the state legislation is very specific about the requirements of what it is that has to be in the new oversight committee. So we're trying to work on that and make sure that it checks all the boxes and meets all the constitutional requirements, and that we can get it through Metro Council in a sufficient amount of time to make sure that we're in compliance so that this body can continue moving forward, though it may look different.
And then I will cede or waive the floor if anybody, board members, have questions, but I don't think it's hyperbole to say that although the state legislature did take a shot at us, we're still here. Preemption is not abolition. So the biggest threat right now, I believe, to community oversight as we know it is not the actions of our state assemblymen and women, but the inaction of our metro government. If they fail to act, then the Community Oversight Board, as we understand it, is at a real risk of being terminated. But we are still here. We plan on still being here. There's still a lot of work in community oversight to be done in Tennessee and particularly in Nashville. And we hope and look forward to our legislators doing what they need to do to reestablish us.
Any comments from board members? All right. Thank you, Tricia, for the update on the legislation. And Daniel, you're right. We are still here. And so from my experience being a native Nashvilleian, Nashville, Davidson County listens to its voters. That may not be happening on the state legislature in the state of Tennessee, but I know Davidson County typically listens to their voters. And so we had 135,000 voters speak to say that they wanted the Community Oversight Board. So I'm sure we'll be working with Metro to ensure that we have some form of oversight in the metropolitan government. Thank you. Go ahead. Member Holloway.
Yes, it is good that we band together and not let them split and divide us. The people have spoken when they went to the polls and voted for us and have given us great support for us to operate in this city so they will have a voice other than the police department, a civilian voice, somebody they can trust. And not saying they can't trust the police department, don't get me wrong on that, but they feel more comfortable having someone on their mutual standing with them to be able to hear what they have to say and be able to come forward with their support, even though they may not have the funds or the legal advice to help them move ahead. But they are very excited that we've been in existence this long, and very grateful. And for us to go is just null and void. And we're here because we want to be here, because we want to represent our peers. And whatever we can do to keep this rolling, we will. Thank you.
All right. Any other comments? All right, we will move to Assistant Director Kylie for our FY24 budget update.
Thank you. So the good news is we are in the budget. That is moving forward. Where we stand right now is that Director Fitchard has put in some inquiries to Metro Finance because while we were in the budget, there was some question about the allocation being a little bit lower. We think that's to do with the lease and our office move kind of being in flux. So I think by the next board meeting, we should have all that information. I know that she had emailed them some stuff this morning. We are meeting with Council Member Suara on Saturday, May 27th to discuss our budget. That is something that that council person does regularly to involve the community. So hopefully we'll get some community participation in that too, and things that they think we need to do. But yeah, right now we're waiting for more information on the rental reduction, and in terms of the legislation, the transition and all that stuff, in our budget, there is a footnote in there allowing Metro to transfer our budget over to, so if we become a different organization or whatever, that should all be lined up. But yeah, that's all I have on the budget for today.
Any comments? Secretary Carter.
Just a question. Would it be possible to get, if the other board members want it, to all the board members, a line item budget with a last year or the current actual budget versus proposed numbers, see where things are?
Yeah, I don't see why not. I don't have one handy because
No, I mean, get from Metro
they
Finance
wisely
if you
don't
can.
let me touch the budget, but
Right.
yes, I think we should be able to get
Okay,
that
thank
pretty
you.
easily. Yeah, I'll mark that down.
All right, so on the record, you have requested a line item budget
Yes.
from Metro Finance?
Current approved and most recent proposed.
Okay. All right. All right. So we will revisit that at our next board meeting. Now we will have our policy advisory reports update by Gavin Crowell-Williamson. And before you get started, I'd like to take the liberty to welcome Councilmember Porterfield. Thank you for being here at the meeting and welcoming us to District 29. Thank you. Gavin?
Good evening, board. I'll try to keep this one pretty brief. I was asked after the last executive committee meeting just to give brief updates on where all our various research projects are, so I will try to do that for you in a pretty brief and comprehensive manner. So really we have like 5 major projects going on right now. First of which is the Sexual Misconduct Policy Advisory Report. The status of that is that we're in the final stages of conducting interviews with MMPD staff. To date, we have completed interviews with OPA, Background and Recruitment, Training, and the Behavioral Health Services Division. And we're now in the process of scheduling with MMPD's HR, their Human Resources Investigations, and Precinct Command staff. We've requested all the relevant data and all the relevant trainings that we need to complete this, and we'll review those when they're ready. And then the final stage that we'll work on once we're completed with the interviews is to do some various forms of community engagement. So we're progressing pretty nicely on that. Next is the use of force reports that was brought to you last month. We have all our code written, the data cleaned, and we've begun to conduct those higher level, multi-level analyses that I was discussing with you beyond just kind of the descriptive information that we presented last month. We are also mapping, analyzing that data, and this week we're planning on taking a deep dive into those preliminary findings and fleshing them out. This does, I think, put us on track with the timeline that was presented last month, meaning that I believe we should be able to have something together by the June board meeting for you all. The next project is our body camera audit. This is a pretty slow process. We began our requests in October of last year, and we are sitting at about 40% of the total videos that we requested as of now. So we're reviewing them, we're auditing them as they come in, but this has been a lower priority for us because we recognize that just based on the timeline of the request, we're probably not going to get all the videos until late 2023 or early 2024, which is really going to prevent us from doing high-level, robust analyses on that. So that's kind of been put on the back burner as we focus on the more pressing projects that we are able to complete and accomplish. We kind of have a twofold process going on with license plate reader data and analysis. We just last week were able to meet with Captain Duncan in a very fruitful way. Captain Duncan is the captain who oversees the license plate reader pilot program, and he was very amenable to providing us with almost all of the data that we were looking for. So we felt that was a very productive and a very fruitful meeting. We expect to be getting the first batch of that from him fairly soon, and so probably by the next board meeting, we'll be able to have sort of an initial round of analyses done on that data, which we're very excited about. And finally, we have just begun to dip our toe into response time data a little deeper. We requested and received more than 3 years of data from the Department of Emergency Communications on response times. And it's pretty messy data, so we've been working a lot with the data to clean it and get it ready for analyses. But yeah, we are sort of doing that cleaning and focusing on exploratory analyses regarding the geospatial and sociodemographic data that we've brought to you in previous months. But we are actively working on that, and we expect to have something to report to you soon. Yeah, I would say all in all, I think we are progressing much in the way that we have discussed we were going to progress. We should have at least 2 reports to present to you fairly soon. We are kind of dedicating a lot of our time and energy on existing reports and things that we can actually accomplish rather than focusing on new projects or proposing new ideas. And I think we'll be able to see the fruits of our labor on that pretty soon. So those are the high-level updates. I'm happy to answer any questions that anybody might have, but I expect to be bringing more to you next month.
All right, Member Holloway.
I don't know if you can tell me right offhand, but for the camera, where are they located? Are they located in a highly commercial area, or are they located in heavily residential area?
It's a mix. They intended to distribute their cameras. They called it an equitable distribution among 4 corridors in the city. I would say generally they rest at high traffic intersections. They're not really going onto residential areas so much. They're more on major pikes and major corridors where you see a lot of pedestrian and obviously transit. They do have a list of all their locations online, and we would be happy to provide a link or send that information to you.
I would like to see that myself, and I'm sure the people, my constituents in my neighborhood would like to have an idea also.
All right. Okay, thank you, Member Holloway. Member Beard.
Yes. Just a follow-up from your report. So I heard you say for the use of force reports and the license plate reader, you thought you could have those done by the June 4th meeting. I did not hear a date about the sexual misconduct. I understood what you were doing, but what is your proposed timeline on that one?
Just a point of clarification quickly. I think the use of force report will certainly be done by the June board meeting. The license plate reader that you're referencing is sort of an initial audit that we're intending to do. I don't think it's going to be a full-blown policy advisory report. It's probably going to be more of an informational report. I also expect that to be done by the June board meeting.
Okay.
As for the sexual misconduct report, it's a little bit more time intensive than these other proposals. It's a lot more mixed methods data that we're dealing with. So I would say probably the July or August board meeting is a reasonable goal for that.
Okay. And then what about the response time data? I understand it's messy data, you need to clean it up, but we did not get a proposed time frame for that one either. Do you have one?
No, because that's not a policy advisory report yet. We are still working with the preliminary data and determining whether it's going to be an informational report or a more formal and more robust policy advisory report. So at this time, I don't have a timeline for you.
Thank you.
All right, that was actually one of my questions, Member Beard, especially pertaining to the sexual misconduct report, because I know we've been talking about this for a couple of months now. And as far as the response time data, Gavin, give us a little insight. I know we had talked about some data that was withdrawn from, from the report that we had initially submitted. Can you talk about where we are with that and what would be submitted? In the likelihood that we would get something in the next couple of months, what do you foresee us reviewing?
Sure. So this was essentially an attempt to sidestep that problem a little bit. What you're referencing is the fact that we initially relied on publicly available data, not much of which, but over 20,000 data points of which was removed from the publicly available data set. And so as a means to subvert that, we reached out directly to the Department of Emergency Communication and got all data that they had, and they should be able to be a central repository and have all that data, all the response times data. The issue is that there are often missing data points for one of the various call response times within that. So we're working to kind of clean that up and make sure that when we're looking at various data points, we're doing so in a thorough way so that we're not reviewing data with gaps or data with missing values. So in theory, this data should have a time in which the call came into DEC, a time in which an officer is dispatched to the call, and a time in which the officer responded to the call, as well as the specific officers who responded and the location to which they responded. So we're going to try to use those call response times as well as geographic information and potentially officer demographic information if we're able to kind of dig into that to proxy out a number of questions that we have about it.
So we'll be able to associate response times in conjunction with the geographic location of where those calls came from within the city.
That's certainly the goal. Working with geographic data often comes with lots of challenges. It gets reported in all sorts of different ways. Sometimes you get a mile marker on the expressway. Sometimes you don't get a full street name. So we have to do a lot of work to clean that data up and make it readable. But yes, that's definitely the goal.
Okay. All right. Does that conclude your report?
If there are no further questions, then yes.
Any additional questions? All right. Thank you.
Absolutely.
We will now move on to the proposed resolution reports. Gotcha. All right. So what we will do now is the executive director's report. And in the executive director's absence, we will have Assistant Director Kiley to give that report.
Thank you, new chair. Director Fitchard could not be with us today, but on behalf of her and I think the staff and I'm sure the rest of the board, just want to say we're all very happy that you're stepping up to serve as chair, and we're all very aware of your strong record of public service, and it's great to have you here during this transition, for real. Yes. It really is. So in terms of employment, we hired a new administrative service manager. That person will start employment on June the 5th. An investigator, one of our senior investigators, retired at the end of April. We hired one new investigator at the beginning of May who has already started, and then we have one vacant investigator position which was just posted, I think, this morning, and that will be up for 10 days. Since the last board meeting, staff has participated in a number of training events. One of those was, excuse me, hang on a second. Computer's acting up. Thank you. Was NACOL's Investigators Roundtable, which included oversight investigators from across the nation, and also one on bias in the interpretation of video evidence. Upcoming in terms of those events and staff development, NACOL's annual conference is being held November 12th to 16th in Chicago, my former home, and we will be sending a number of staff members to that. Additionally, both Executive Director Fitchard and Gavin Crowell-Williamson were selected to be guest panelists for that year's conference, so congratulations to them. It's a nice honor for our office. Upcoming community events, there will be a Dine and Learn with the Egyptian community hosted by the Alhambra Center. Executive Director Fitchard and her team, I'm sorry, that already happened. A Dine and Learn with the Egyptian community, and Executive Director Fitchard and Ms. Robinson shared information about COB and the complaint process and how we kind of work. This past Saturday, we also had a family event at the Magruder Community Center with a number of other Metro agencies, Metro Action Commission, the Public Defender's Office, Public Health, Mental Health Co-op all came out to meet with members of the community, so that was great. And I believe we'll do upcoming events when we get to new business. But those are all the executive updates.
You have any comments or questions regarding the executive director's report?
Okay,
All right.
move into the PRRs.
All right. Thank you, A.D. Kiley.
Well, we're still without a quorum
Right.
currently, so
Okay.
I do have some questions about the executive director's report unless there's some board member.
Please do.
You said we had hired an administrative services professional and a new investigator. Has that been confirmed with them? Is there any details you can share about them, or is that?
Yeah, the new investigator has already started. She's been with us for about a week and a half now. So she has already started. My understanding on the administrative services manager, I do believe that's finalized. I believe there's been an acceptance. That's what I was told, but I do not have a start date. I know that Director Fitchard said she was trying to get that start date set as soon as possible, just because of the need that we have in the office, but I don't have a date.
You got one more?
What is the administrative service manager do?
So currently, Director Fitchard is handling a lot of the HR, the budget, onboarding new staff and all that stuff, and it does take up a very considerable amount of her time. So the person that we hired, we're hoping will be kind of more in charge of the budget as a full-time thing, and also help just HR type issues, kind of nuts and bolts stuff.
All right. Member Holloway?
Normally, when we get new staff members, it's always a requirement for me to ask, if possible, can we get a chance to meet the new employee
Oh, I'm sure,
at our
yeah.
next meeting?
Yes, I can ask her to come to the next meeting. I'm sure she'd be happy to.
You mentioned names, so I'd like to know who we're
Ms.
talking
Kayla
about.
Cleggett is our new investigator, and she's previously worked for the state of Tennessee as an investigator, so she had a pretty good resume, and she's been great so far.
All right. Okay. Member Brown?
Let me ask one question. I notice we've got a number of people going to various training and such, and we've got a backlog of PRRs. Given our uncertainty about what happens past 120 days, is that time better spent trying to get the PRRs finished?
Well, it's obviously a few moving parts. I would say this. I think that we have a staff of very, very dedicated investigators. But I think that mechanically speaking, we do need training across the staff. Currently, I'm filling a lot of those gaps in terms of making sure that the investigative reports are up to snuff and so on. And so I think that our folks work really hard and they're very dedicated, but I do think ongoing training matters, especially because even in the new iteration of whatever this organization looks like, even if we're doing audits still require a lot of the same skills. And, you know, for, I think, laypersons, analyzing a lot of the body cam, you know, you do need a legal knowledge to an extent. You know, you need to understand reasonable suspicion and things like that, and also just the extent of the policy stuff. So I see your point. I don't think it's a ton of time. I mean, the NACOL webinars are an hour and a half. So they're not a huge time deficit, and it does give people just a little bit more, you know, things to think about, and kind of keeps us in touch with what other organizations are doing around the country, and, you know, try to keep our standards as high as anyone else's. But
Member Brown, do you have any more?
No, I'm more concerned about those that are out of state. I mean, a year or so ago, we had the whole staff went for a week to training.
to Chicago.
Yeah.
Yeah, I think this and I spoke with Director Fitcher this morning, and I think this year is not going to be the entire staff, fortunately, because we also have more staff now. So we can send just a chunk of the folks who haven't been before, I think is going to be the priority, so it won't be like the entire office is gone.
Okay. Member Beard, I'm sorry.
Oh, that's okay. I don't know if this is the appropriate time to ask the question, but it's just along those lines of what Member Brown said. I was looking at the backlog as well and was concerned. I think we brought this up last time. You know, we asked for more of the CPRs to be presented. And then if you look at the backlog, there's a number of them that state that, you know, it's hundreds of days that they're backlogged. There are a number of them that seems like they're waiting on the final review. The ones that we are seeing today, they were 6 months and 4 months respectively from the time that the draft report was done until it was presented. So I don't know if sometime in this meeting we can talk about how do we prioritize, to Member Brown's point, if we're not here, what is our goal? What are we doing to ensure that we are doing the most that we can based upon the charge that we have, right? So that is to investigate, to offer recommendations, you know, just the two that we have today. It's unsubstantiated. So why aren't we looking more at CPRs that have, where we can make recommendations to the police department? So I really think that at some point in time in this meeting, if we have the time, and I don't know if that's under new business, that we look at this backlog and as a group decide, are we going to try to figure out this backlog based upon the timing that it's been waiting to be reviewed? Are we going to do it based upon the status it's in today? Are we going to do it based upon the subject matter? Are we going to do it based upon whether it was a community complaint or a directorate complaint? I just think we need some type of plan moving forward in case that we are unfortunately ended in September. But that's my concern. You have
Secretary Goddard.
Yeah, my understanding is, and anybody that knows, correct me if I'm wrong, is that the chair has the authority to amend the agenda on the fly. And I would like to request that we amend the agenda, that you amend the agenda right now so we can discuss this. I have a motion I'd like to make on that as well.
Okay. Do we have a quorum?
I'm sorry, we do, yes.
We do have a quorum.
We do.
All right. Secretary Goddard.
All right. Member Beard, this goes back a full year and a half of encouraging that we try to get more done in this and that. Judge Brown was the first person to raise that. Numerous of us have, numerous times. many times have asked for at least 3 PRRs to be presented at a board meeting, as we did last meeting. I share your concerns. I don't think, I feel uncomfortable getting into the specifics of trying to direct too minutely the actions of the staff, but I think we do have to set some expectations, and they do have to have some explanations if those expectations aren't met. And I would like to move that the board requests and directs that the staff present a minimum of 3 PRRs per meeting going forward.
And can we add a little bit to that about the timing or the subject matter?
Can I maybe?
Let me step in here. Attorney Yoon, give us some direction on what you think would be best if we do increase the number of PRRs that we review, and then can we break them out, if you will, as far as like subject matter and days under review, whatever kind of category that we would like.
Sure. And I'm talking about some high-level guidelines, not the minute.
I know.
As he's saying, but I'm just talking about some high-level guidelines of what we would like to see regarding those 3.
So I'm representing an organizational client, right, with 11 board members, and I also operate on staff with the executive director, underneath the executive director. So just know that my head is sort of with that in mind. So some of this is going to speak to, I think, as a staff perspective who does participate in the workflow and the creation of these reports, but also in sort of advising the board on some of this high level. I want to hear from Director Kiley, Acting Director Kiley, on this, because I think he can give you some of those details. We have had some of these meetings, and I just want to put it in perspective too. We were without an assistant director for about 11 months, and the assistant director in our job responsibilities is the organizational head supervisor directly of all of our investigative staff and intake. I come in as the legal advisor in the workflow with the proposed resolution reports, and obviously the executive director approves both of these 2 things and oversees it. So with Mr. Kiley coming in December and operationally really taking effect in January, and then really asking for y'all's sort of patience as we get through these numbers, I appreciate it. I want to encourage board members to continue to look with a very, very fine comb at our reports that we give out. But know that we are having these minutia level meetings about subject matter, which ones to prioritize, which ones not to. I want to say it's evidenced in this report, although not in the aging report. There was a discrepancy that I only noticed when Judge Brown reached out to me. It reflected that we still had 60, and that's not true. We have 48, I believe. Okay. So I think, are now seeing the consequences of the work that we've been doing since January. We went from 60 to 48 in 1 month. And if we continue with that trend, an average of 10 per month, knowing that the 120 days expires October 29th, which is 5 months from now, then operationally we should be able to see all 48, 10 a month, closed out before the 120-day deadline.
What happened to the other 8?
Could I please
Sure,
respond to
I'll
this?
turn over
Thank
to
you
Mr.
very
Kiley.
much.
A.D. Kiley.
Okay, so we have spent the last couple weeks cleaning up IA Pro and doing a lot of housekeeping. That has resulted in a number of cases going to mediation that were discourtesy complaints. So only discourtesy, nothing more complicated than that. Those are being routed to mediation. So some of that is taking some pressure off of investigations. The other reasons that cases maybe come off the list is that some things are on hold because they involve pending criminal or civil litigation. And then several were administratively closed because we reached out to complainants who either did not want to pursue them anymore, or they had, I think in at least one case, they had gotten an answer from OPA they were satisfied with, so they let that go. So all of that is to say, none of Member Beard's comments are lost on us. This is a huge priority for us. It is the only priority for us. And getting some of that cases that were just stale or kind of clogging up the pipes, getting those out of the way, disposed of, and on their way to getting taken care of was kind of step one, just so we have a clearer picture of what we're looking at. This month also, I would say we have kind of switched gears. So the complaints that I'm working on right now are both ones that I think would go to your point. These are more serious, just more serious complaints. And to echo what Attorney Yoon was saying, when this spot was vacant, when there was no AD, and with Attorney Yoon's time being taken up by other things, frankly, we didn't have anyone on staff who could do an officer-involved shooting report. We didn't. So I'm trying to take that on. Those are very work-intensive, obviously, but we have prioritized those. So I wanted to give you some assurance about that. And we can certainly talk about the details, but your point is very well taken, and that is what we are currently trying to do.
Okay. Any other questions or comments? Yeah.
Yeah. A couple of things. The motion still stands.
It does. Right.
Okay. I'm feeling better. A couple of comments. I hear what you say. A number of those that just aren't being processed anymore. If somebody waits a year, some number of those aren't going to be interested in picking up and going and carrying forward. So we don't know how many of those there are. The way we speak to the police are under the ordinance are basically two things. One are the policy advisory reports that has been mentioned. We've done a lot of, and they've accepted a lot of those. And
right.
That's the other way is with PRRs where violations are found and where we make recommendations, both as to what is a violation and what the characterization it is within the penalty grid or the consequence grid and what we recommend. And I'm happy that we're clearing out the backlog, but I'm unhappy that we've got 2 PRRs today, and both of those give us no opportunity, as Member Beard mentioned, to make a recommendation to the police department on violations and actions. So my motion stands, and I would like to see us have at least 3. I'm not going to put in the motion. Personally, I'd sure like to see a few that actually had violations found in consequences, if the facts warrant that. We can prioritize those, but the motion is to have 3. I'm sorry.
All right, we have a motion on the floor to review at least 3 PRRs at each meeting. Is that right?
That's correct.
That is correct. Can I have a second? Is there a second? You've already seconded. All right. All in favor? Say aye.
Aye.
Opposed? Motion passes.
I just had one comment, if I may.
Go ahead.
One other thing that has slowed up the process is after we had made a recommendation, and it goes to the police department, and then when they get around to responding back to it take a little bit longer than we expect. And I think we had to ask them to give us a better response than what they have already given us on some cases, you know. And so we don't run their office over there. That's definitely true. But I think in some cases, you know, they could speed up the process on some of those cases, which would help us a lot of time to make our decision, you know, and so we can clear the cases, you know. So I think we're doing the best we can and going to work harder.
I agree. Any other comments or questions? Member Brown.
I went through the aging report with took some time to go through it, and because apparently I can't send it directly to the members, I sent it to the director and assistant director and our legal advisor. But I went through the aging report that we have for today, and frankly, it's a disaster. And assistant director gave me a response back that updated it, but it frankly just showed that we were showing stuff that had been closed, that was over a year old. It showed no action. It showed reports had been sent to the director 3 months ago, but nothing else. And so I would like to have my email to the director and the assistant director's response provided to the board members, so we see exactly what's there. It has cleaned up, but a lot of it.
You simply can't hear you. You speak a little closer to the microphone. Maybe.
Sure. It did clean up a lot of cases that should have been off the report months ago. So I have some doubt that we're going to be able to move as quickly, reducing down by 12. But I think it would be helpful if the board members would take a look at what the aging report showed that we were given for today, as opposed to what it actually should have shown and what was done. And you mentioned, Mr. Holloway, that about the police reports. We showed that there were 2 reports that were 81 days old. Mm-hmm. Well, it turns out we had no recommendations in them at all, so they weren't old. So we threw a rock that when we're in a glass house on it. The police department has been within their 45 days on everything we've sent them that required a response. And so I think we have to be a little more accurate in what we're doing and taking a little more care in that aging report to the board, so the board has some idea of what the problems are. So I would request that my letter to the director and the assistant director's response be put in the record and provided to the board members.
Okay, so what I hear you saying, Member Brown, is that you are going to write a letter?
No, I wrote it and I have a response.
Okay, and so it is directly tied to the accuracy of the aging report. Okay.
I went through and looked at every one of them, asked questions about it, and I got a thoughtful response back from assistant director. Unfortunately, it didn't come in red for some reason, so it was a little hard to sort it out, but he gave a response on 90% of them, but it just shows, that frankly it has not been given the attention it should have had.
Attorney Yoon.
I don't see a violation, but if I can offer an alternative to just put that to rest. I know that the Tennessee Open Meetings Act, I know that sometimes email is being sent from a board member to the entire staff can be seen sometimes as deliberation. So I would much prefer just to say, and if this doesn't get to what you're wanting to get, then we'll proceed with what you're talking about. Like I said, I don't currently see a problem with that. But
problem with what?
The Tennessee Open Meetings Act sort of prohibiting any board member to other board member deliberation. I don't see that in what you're suggesting. I'm just proposing that perhaps
I would have been happy to have sent it to the board members, but I thought it was a problem.
Right, and with that guidance, and I appreciate that, and I would say, please continue the same track. But what I'm suggesting is, I'll just make known today that in your email, and I guess what you're currently asking for is the idea that we have 2 reports. We have a report that the director keeps, and we have a report that is sort of our internal database that we've been sending to you, sort of routinely created update of every case, and those 2 lists are not the same. And what Director Kiley was able to give you is a accurate, I think, update on every single case that we have. What I'm going to suggest is that we send that update from now on, and the one that we sent you, we can update and send to the rest of the board now. So that sort of, again, it's not sending your email to all of the board. It is Director Kiley, at your request, is going to be updating the board on every single case that is in our database that we sent out to you previously that was just frankly not correct. It reflected 60 active cases. We really have 48. And going forward, we are going to put into the workflow. Myself, I'm going to be looking at Director Kiley's list and updating IA Pro to make sure that it is accurately reflecting what y'all see every meeting.
I guess I'm a little concerned that you're saying you got one list that was accurate that you don't send to the board. You've got another list that's not particularly accurate that you do send to the board, and that concerns me.
Absolutely. Until you brought it to my attention in the email, I did not know that our aging report was inconsistent with Director Kiley's report. Just simply, I don't see the documents that go out to the board every month. When you email responded and CC'd me on it, I then saw, oh, this is different than the report list that I see. and there's at least 12 discrepancies on it. So like I said, going forward, and again, a lot of this has to do with, we had 11 months without someone fulfilling that role. So now that someone is, now that you are seeing this routinely, I can now see where the discrepancies are.
All right, Assistant Director.
Just to briefly address Member Brown's comment, because that is a valid concern. It's not that there are two sets of numbers. It's that IA Pro is a piece of software that is very old, and it is very inefficient to use. And so part of this issue is that we are asking the investigators to be much more diligent with making sure that that data of when dates, especially when they go in. Because with IA Pro, not to get too far in the weeds, but you have to tell it to do something about 6 times before it does it. And so we're trying to emphasize that to them, the importance of it in the process and for our transparency. But the other thing is, what I had done was gone through and just made a big spreadsheet. And in there were a lot of notes that I had made about the cases. A lot of that stuff gets into confidentiality, so I didn't want to just email that to you guys. But that is part of the process that we were trying to get IA Pro up to date so that it is accurate, so that there are not these weird discrepancies, because it is important.
All right. Member Holloway.
Mr. Brown, you're not understanding what's going on. When you're short, you're going to be short. We've been preaching this for the longest. We need more people. We just got our assistant director right here. So if we don't have what we need, quite naturally we're going to be short. When we get what we need and you see a shortage, then you have something to complain about.
Member Beard.
Well, I'm equally concerned. I actually went through the aging report and I went through the complaint log. And I guess if we're saying now that the aging report is incorrect, is the complaint log incorrect as well? Because wouldn't the investigating aging report reflect the complaints that are open? So is that the same database? So you have a complaint log that was sent out, and then you have an aging report that reflects the age of the complaints. So are both of those documents need to be updated based on what we just discussed?
Attorney Yoon.
I would imagine so, only because both of these reports are, to a certain extent, auto-generated before the board meeting. And again, I appreciate the scrutiny. I think if we can't explain it to you well, then we're not explaining it to ourselves well, we're not explaining it to the public well. So I want this level of review because I do think we're getting better, and we're going to see, if we keep looking at these same metrics, better data. We won't get better unless y'all give us this kind of review and critique. So I don't know how to put it, but when you're clicking on some of these drop downs, if you don't put it in a certain category, such as status update or case conclusion, it won't reflect in the time. It won't reflect in the status update. You'll see an old note instead of the new note. So some of this has to do with, again, investigators putting in the information, but also putting it in under the right category. And then that's where I really think that Director Colley has done a great job in the sort of direct supervision and weekly follow-ups and daily, multiple times sometimes, check-ins to make sure that we're getting to that point. Like I said, I hadn't been doing that, so I didn't see where this complaint log and where this progress report were not, again, I keep saying the word accurate, but I mean, I don't know how else to put it. Like, it's not as, well, at least at least the auto-generated report isn't even reflecting all of the notes that are being put in there by our investigators. So I don't think it's as helpful of a document as what Director Kiley produces. But that does include confidential information and names that we generally redact before sending to you. So, like I said, these are things that we can fix and things that we can work around to get you the accurate information that you've been wanting.
Member Beard.
So I'm taking from your comments that we should receive an updated investigative aging report and a complaint log, updated for both. Both should be updated and sent out.
That's my proposal. I think that if we apply the scrutiny now to our aging and complaint report that we auto-generate, now that we're going to have an extra set of eyes on it, and it's going to be specifically to compare that with the assistant director's log, we should be able to correct what has looked like again, an aging report that doesn't reflect where our current active caseload is. I don't know that's going to fix the time problem. Again, that's going to take actually logging the time that has been spent on each case in the right category. So that's probably not going to take place by just looking at status update. Is that accurately reflecting whether it's closed, suspended, submitted to the director for review, submitted for PRR review? That is the portion that I'm suggesting is going to get another set of eyes on and should be accurate for next meeting.
Thank you. And just one follow-up question to that. It goes back to Member Brown's statement that about the training. Maybe we need to do additional training on the system that we're talking about, or I don't know.
We need a new system.
Okay.
The system
But since
is
the
old.
system we have is
It is what it is for now, and so,
Okay.
yeah, it's a matter of just trying to reinforce that, we're trying to keep good records of when are we requesting things from MNPD, when are they providing it to us, when did you reach out, to schedule an interview, when was the interview held, and I think that over the last, in 2022, just to be completely frank, because it's in there, I think a lot of that stuff just wasn't being logged, and that's not great, obviously, but that is a problem that we have recognized, and so that is, it's a good point. So we're working on it. Yeah.
Thank you.
And were we not looking at another system?
Yes. Yeah. There are a few. I don't know where that is at right now. I don't know. There's a newer version of IA Pro. There's also a software platform called Civil, and I think that we are still trying to decide between those.
Which is Muse. Thank you. Member McCree.
I think the assistant director answered my question on that one. I know we had extensive conversations about our new system because this clearly was not working for us. And there was conversations with the IT department, several conversations that happened about how do we remove all of the information that we have in this system now to get it over to a new system without crossing any confidential barriers. And so is it possible to have an update on what that process will look like by the next board meeting?
Yeah, I'll put that on to talk to Director Fisher about. Thank you.
All right. Member Goddard.
Real quickly, there were several comments made, and I can certainly agree with the members that made them on resources.
Your microphone.
And inability to do, I'm sorry,
No, we can hear you.
inability to do a full job without full resources. The assistant director position, I'm pretty sure, correct me if I'm wrong, was fully funded this whole period we were without one, I think. It just took a long time to get, we did a great job. We finally filled it, but it took a long time to get it filled. Thank you.
All right. Any further discussion? All right. Yeah. So now that we have a quorum, we will go back to the approval of minutes. You all should have received the meeting minutes from.
If I can interrupt,
Go
I'm
ahead.
sorry. The draft minutes from staff were sent out. I had revisions. Those didn't get sent out. I think Director Fitchard intended them today, but is out today. So I would suggest that be deferred
I
until the next
received
meeting.
revised minutes. Did
Y'all-
anyone else receive
Everybody-
revised minutes?
Never mind.
Yes.
I take it back.
We received them.
All right, great. Okay.
Thank you.
That would be the ones.
All right. So if we have any comments or questions regarding the meeting minutes? Thank you. Thank you, Member McCree. All in favor?
Aye.
The meeting minutes have passed. Now we will go on to our PRRs. Assistant Director Kiley.
Okay. I will start with PRR in case CC 2022024. On May 20th, 2022, the complainant submitted a complaint to MNCO alleging that on January 16th, 2022, following a winter storm, a resident in the same apartment complex as the complainant had parked his vehicle in the middle of the road. Two employees with Metro Nashville Police Department, Officer 1 and Officer 2, responded, and the driver of the vehicle moved the car, but moved it in front of the complainant's house on the sidewalk and partially blocking her driveway. The complainant called the police again, and the same two officers responded. The complainant filed a complaint alleging that Officer 1 and Officer 2 failed in the performance of their duties to take a harassment report, that they did not issue a citation or ticket to the individual who had parked his car in front of the complainant's home, and that they did nothing to ensure the complainant's safety or protection of their rights. We analyzed that case for under the Metro MNPD policies for deficient or inefficient performance of duties, private property and towing of cars, and under the Tennessee Criminal Code standards for harassment, since that was the basis of the complaint. The findings of fact were that of our investigation, that on January 16th, 2022, the complainant called the non-emergency phone number from MNPD to report a vehicle illegally parked on and in a driving lane of Ned Shelton Road within the boundaries of Davidson County. The complainant reported that this was not the first time the driver had done this, and upon reviewing the body-worn camera, the owner of the vehicle could be seen confirming he had parked on the roadway previously to the responding officers. On the date in question, the complainant saw the owner park his vehicle on the roadway and told him that she was going to call the police if he left it there. At approximately 7:43 p.m., 2 officers responded. When the officers responded, they spoke to both the complainant and the owner of the vehicle, explaining it was very unsafe to park his vehicle with it half on the shoulder and half in the road. The owner of the vehicle explained that the icy conditions and the very steep incline made it unsafe for him to park further into the complex. The officers suggested multiple areas near the complex entrance where the owner could safely park, and he agreed to move his car. The owner did ask if he could park in front of the complainant's home, and the officers said no, and warned him that if he did, they would return and could potentially charge him for disorderly conduct, or a private towing company could tow him. The officers again suggested multiple safe places to park, and the owner indicated he would do so. After the officers left, the complainant called the non-emergency number again at 8:16 to report that 8 p.m. to report that the owner had parked in front of her apartment, partially obstructing her driveway. Officer 1 returned to the scene. Officer 2 did not, because he was responding to another call. Officer 1 spoke to the complainant, told her what his advice had been to the car owner, and agreed to write up an harassment report against the car owner. Officer 1 explained that MNPD policy, prohibited them from towing the vehicle since it was now located on private property. Officer 1 spoke to another officer via radio and confirmed that that was the policy. Officer 1 provided the complainant with a receipt of the incident report of her allegation of harassment. It is not in dispute that the actions of the vehicle owner were frustrating and potentially unlawful. And unfortunately, the MNPD policy is that they do not tow vehicles in violation of law if they are on private property. Based on the evidence, we conclude that the allegations of deficient performance of duties against, well, actually, let me skip that for a second. Let's go to the discussion. So in our analysis of the facts, Officer 1 and Officer 2 both responded to the request in a timely fashion. They spoke to both the complainant and the car owner appropriately. They conveyed accurate and helpful information to both parties to try to resolve the dispute. During their interaction with the car owner, they offered a couple of different options available where he could park and still avoid the steep, icy road conditions. None of the options presented were for the car owner to park his vehicle in front of the complainant's home. Upon returning to the scene the second time, Officer 1 asked the car owner to move his vehicle multiple times, and the car owner admitted he was being petty and refused to do so. Officer 1 called another officer and received confirmation that MNPD was not allowed to tow the vehicle since it was on private property. Officer 1 expressed sympathy to the complainant for the frustrating actions of the car owner, explained the MNPD policy not to tow cars that are on private property, and instructed her on her option to call for a private towing company. So based on all of that, by a preponderance of the evidence reviewed, the executive director concluded that the allegations of deficient or inefficient performance of duties against both Officers 1 and Officer 2 are not sustained and makes no recommended action.
Questions or comments from the board members? Member McCree.
I'm ready to make a motion if there's no further comments or questions.
All right.
I move to have this PRR accepted as is and sent over to Chief Drake.
Member Brown, second. All in favor say aye. Aye. Opposed? All right. So that motion has been accepted.
And in regards to that report, we did have an impact statement from the complainant. I understand it is the board's prerogative whether to have her read it or to have me read it. She is present.
If you would read it, we will have public comment after both PRs have been reviewed.
Okay, so read it now?
Yes, please.
Great. This is the complainant's written statement that was submitted to us by email on May 16th. On January 16th, 2022, I called the non-emergency phone number to report a vehicle illegally parked on and in a driving lane of Ned Shelton Road. This was not the first time the driver had done this, which he stated himself to the responding officers. I had witnessed the driver park his vehicle there, and I told him I was going to call the police. I am going to provide details and facts that were omitted from the PRR. All of this can be verified in the body cam videos, and the incident numbers, I'll redact those, but we have those available. These incidents occurred back to back. The responding officers to the first incident were Officer, can I say the name? What? Officer 1 and Officer 2. Thank you, Mr. Yoon. All of these events occurred within Metro's jurisdiction, where these officers are sworn to protect and serve. When the officers responded, they encouraged the driver to move the car and to park it in places that were not reserved for parking. They encouraged him to park on the grass and at the entrance of the complex, even if it would cause problems with other residents in the HOA, anywhere except for where the police would have to be involved. This was one of the first things Officer 2 suggested to the driver. While the driver was talking to the police, he stated he would park in front of my home, quote, to piss her off, end quote. Officer 2 warned him about disorderly conduct at that time. The driver moved his car, but the officers did not stick around to see where he moved it to. And as you now know, things escalated. The driver retaliated against me and parked his car on the sidewalk in front of my home, partially blocking my driveway. This was harassment. I did not consent for him to be on my property. I did not consent to him leaving a 3,000-pound object in front of my driveway. I immediately called back to the dispatcher and asked to have the officers return. Officer 1 responded. Officer 2 did not respond, which was incorrectly stated in the PRR. Officer 1 acknowledged that the vehicle was blocking my driveway. Officer 1 stated that he would file an intimidation report. I never received one, nor have I received an apology from Officer 1 for not providing one, or an explanation from MNPD or Officer 1 as to why one was not provided. Officer 1 misled me, and the police report's conclusion was that my call for service and complaint were quote-unquote unfounded. Very little was written in the police report. It did not mention the baseball bat that the driver brought out from his home. However, it did mention that the officer, quote, understood his predicament, end quote. These officers did nothing to ensure my safety, my security, my protection, or my rights. The driver first parked illegally on Ned Shelton Road. When he moved his car, he then parked illegally in front of my driveway. The state of Tennessee Code 55-16-111 allows a vehicle to be towed if it is blocking access to public or private property. 12 hours does not have to pass in this situation. Metro Nashville Ordinance 12.40.130 states, no person shall park any vehicle in such a manner as to block or impede ingress or egress from any public or private driveway or garage. The driver committed an obvious parking violation. MNPD Code 6.20.030 authorizes the police to impound any vehicle parked within its jurisdiction when the vehicle is in violation of any ordinance of the Metro government. These officers had jurisdiction and authority to write a citation or ticket and to tow the vehicle. It was Officer 1's idea to have the vehicle towed, but this did not happen because of Officer 1's inaction. What the driver did could also be classified as criminal trespass by motor vehicle, a Class C misdemeanor, Tennessee Code 39-14-407. The driver was blatantly disobedient, yet Officer Flick and MNPD chose to protect him and not me. I do not feel that the PRR is representative of the facts or related laws in this case. It is also obvious that these officers did not do what they were sworn to do. And that is the end of the comment.
Okay, questions or comments from any board members? Member Brown.
I guess I'm concerned if we get the PRR and we vote on it, and then we get all this other stuff after we voted. This seems to me sort of be backwards. Am I missing something? Is this the way we have to do it? But
Attorney Yoon and then Member McCree.
I'll defer to Ms. McCree if
All
she
right,
can have
Member
answer both
McCree.
at the same time, maybe.
Well, to answer your question, I know this is the way we've always done it, because if we hear the personal testimony before we review the facts of the case and before we vote on it as a board, that may alter our decision. However, I think when we have cases like this where additional information and perspectives are brought forth, that is important. And some of this I did not see in the PRR. This may have been in the documents that are located in the office. And again, we've talked a lot about access to the building and what that looks like for board members. But that was not information that I saw in the PRR that we had here today, which reflected my vote. And so I wanted to make that clear.
Attorney Yoon.
So that's correct. We've always had the rules that we've been handed. Only a handful of board members probably were around when those rules were made. And when reviewing those decisions, there does seem to be, an emphasis placed on protecting sort of the process over perhaps even accuracy. They want to finalize the investigation, let y'all see it without what might be considered a back and forth. For example, at a trial, somebody testifies, that person is subject to cross-examination. We don't do that here, but that would be fair if somebody did want to provide a statement post our conclusion and then let the other side ask questions. So I guess to prevent that back and forth, we do it this way. That's not to say it's the best way or that it doesn't lead to other problems, but that I think was the intentionality behind it. And then absolutely, all of this is subject to review. All of this is subject to reconsideration. And we can answer questions now about some of the findings that you may find discrepancies in what the statement impact had in it. So that's what the purpose is right now. If you have questions.
Thank you. And that goes back to, listening to the statement. And so if we're hearing about baseball bats and other factors that could sway or kind of imagine what we think is fair and adjust a decision, then I think we should be asking those questions and should dig a little deeper. Member Goddard.
I probably go back as far as anyone. I was on the Rules Committee my first meeting. I wasn't even sure what the Rules Committee did, but I got put on it and learned from there. My understanding of how the process is supposed to work, and against that we have to throw each individual case, is that the staff will fully investigate. The complainant will have a full opportunity to give any facts they want. If in interviewing other witnesses they find other questions, come back and have a full investigation at that level, not two attorneys cross-examining, all that sort of thing. That's what we're relying on, is the staff to give a good and thorough investigation. And the thought was, if that happens, if that's done well and it gets to the board, we're faced with either the situation we have now where a complainant may raise additional questions or state other facts later, or having a whole second investigation and trial in front of the board on these things. And right or wrong, I think it was right. From early on, it has been, we'll do it the way I just described. The staff will do the thorough investigation.
Member Beard.
I'm the newest one on the board, so my question is the information that was just read, was that provided to the investigators? Did they have that statement when they investigated?
I don't think we had this statement, but we did have that information. If you want me to speak to the BAT, I'm very happy to speak to the BAT.
So all the information that you had there was given to the investigators?
We did not have the complainant's response at the time because it's a response to the report.
Thank you. Okay.
Yeah. But in terms of the BAT was addressed in our investigative report. We did not include it in the PRR because we determined it to be irrelevant. The reason we did that was that when we're reviewing the body cam, the gentleman, the first interaction, when both officers are there and they go to his house and they tell him to move his car, he comes up with them to the road. The three of them are standing there and the officers are telling him, here are some places you can put your car. He is carrying a bat. The complainant was not present for that. The bat was never displayed to the complainant. It was not within 20 yards of the complainant's home as far as we could figure, so as far as we saw. So the bat, while while that sets off a flag in people's minds for sure, it did not seem relevant. The officers talked amongst themselves about it, and they were sort of like, why does he have a bat? And they thought it was maybe because the road was very, very icy on this evening. When you watch the body cam, the officers are struggling to stay upright, and I think that they assumed he had it as some kind of a walking stick. But it never came into play vis-a-vis any interaction between the two parties. And so for harassment or disorderly conduct purposes, we did not think that was relevant.
Member McCree. Give me 1 second. Member McCree.
I get what you're saying. I also think that something that is critical to the complainant's idea of intimidation or harassment would have been critical to have in the PRR. Because as she, or as they are going through this experience, that is something that they may have perceived as intimidation, which is why they felt like their case was not handled correctly. And for future references, information like that in the complainant side of the story would really be helpful here for me.
Member Beard.
So I guess I'm just still have a question about the process. So we actually receive a complaint, it is investigated, a report is created, and that report is given to the complainant, and then the complainant gets to respond. I'm sorry, I'm kind of...
No, again, it gets kind of confusing.
Yeah,
The complaint comes in through a variety of ways. Our investigator reaches back out to the complainant to receive a fuller interview. They then ask for all the records attached to it, the police report, the identity of the officers. They schedule the interviews with the officers. They create from all of that an investigative report with several exhibits to it, including body-worn camera footage. That's reviewed by the assistant director, myself, and the director, Fitchard. And then from that, we create a sanitized public version called the proposed resolution report that we then release to all of you and we give to the complainant and the subject officers. Nobody sees the investigative file except for board members if they want it. And to go to that point, we'll certainly look at putting in facts and details, more thoroughly. But just to be clear, like, this was something that I do not believe the complainant was aware of when she made her report. She found out after she independently obtained body-worn camera footage and saw the things that she hadn't seen prior to making her complaint and during her interview with us.
So I had a follow-up question. So the document he just read from is what document?
So when we gave the public report that you now see to the complainant and the subject officers, we solicit responses. If they want to have a statement read on their behalf, we will take that. So take it with a grain of salt that this is also coming after a finding conclusion has been made, and there might be details that she knows now that she didn't know when she first made her complaint.
Thank you.
Member McCree.
Okay, so that leads me to a process question. So a couple of months ago, we talked about access to the space, getting the raw reports, to be able to have all of that details, and maybe making it easier in some type of confidential way for board members to get that information. Is there any update on what that process looks like?
The original thought was that we could give y'all temporary passwords and email addresses. We have never gotten a response as of last January, I think, from the IT director regarding that. A second idea that I had was, I'll just send this to you via a password protected Adobe file. So I'm much more comfortable. Again, when we proposed this last January, I was reluctant because I was like, oh, we have something imminent planned. Let's just wait for that to happen rather than open up a can of worms of data hacking and all of that. At this point, we've had board members come directly. We've had board members ask for the file, and I've sent it. So at this time, if you want a file, you ask for it, and I'll do my best. I'll either bring it in person or we'll send it via, email if necessary.
Sounds good.
Would it be easier if you are able to just send it out with the PRRs when they're being sent out?
I'll defer to Director Fitchard on that. Like I said, we've talked about different ways of complying with board requests. I'm not going to say on behalf of Director Fisher that we're just going to send you the investigative file now after all these months that we haven't. But I don't feel comfortable speaking for her at this moment.
Yeah, I was just going to add to that too, and that part of the reason that we keep the investigative reports so close is that those include materials that we get directly from the police department. Ergo, those include materials that are governed by various statutes related to the identities of juveniles, the federal law enforcement databases, and all that stuff. And so we kind of err on the side of keeping that in-house because we don't want to violate any of those rules. But that said, I am also happy. I'm available nights, weekends. I'm always around, so I am very happy to facilitate showing files. It's body cam to anyone on the board.
So at this part of the process, if we request them, you will send them, but you will not send them out with the PRRs to be reviewed when we're reviewing the PRRs.
I mean, I think it's a Director Fitchard question. My hesitancy with sending them out at the same time as the PRR is that it makes me a little nervous that somebody could mix up which one is which, and then we have unredacted reports, and that gives me lawyer angst.
Okay. So what we could do possibly is send out the process, right? Is the process written, or are we talking about something that we've always done, and then it's pertaining to the rules? Can those be sent out as well, especially since we have new members on the board?
Yes, I think the rules that I referenced are publicly available in our website under Rules of the Community Oversight Board. Procedure talks about the investigative file and the proposed resolution report and the exhibits that they contain and whether they're releasable and at what time. Until the chief gives his response, we redact names of the subject officers and the complainant. Even after the chief gives his final response, which is now a public record and sort of makes it more releasable by us, there's still confidential materials in the investigative file that we would redact to non-board members. Board members, you are part of our process and you are able to view things that are confidentially shared with us.
So will you be able to send out the process?
Yes, ma'am.
Thank you. Any additional comments? Member Brown?
A lot of the complaint, and perhaps one way to make an easier solution would be just if with the PRR there would be a note that there was additional something provided by either the officer or the complainant, just to alert us that there is something there. Having listened to it, and Mr. Holloway, I think you could probably answer this, but a lot of the citations that she cites and such in the complaint, those are discretionary. There's no requirement that the police officer actually arrest or do anything on it as a requirement. Now, she has her own right, as I understand, she would have her own right to try to swear out a complaint or something, but the officer is not required to file a violation, even though he might be able to, as I understand it.
It depends on the circumstance, and what has made it much easier for the police department is to do a record of just a record for understanding that a report, a matter record, what it is, that a report was made, and this is what I observed, this is what happened, and then the complainant sign off on the report. You know, not necessarily have to issue a citation on every then, but as long as you investigate and you got a report on file that was made, investigated by the police department, it can be followed up on.
Member Spencer?
I think, particularly as it comes to this situation, respectfully, I do understand like the logic that went through on that, but I do think when it comes to the PRRs and it comes to a potential weapon that can come out in like the public testimony, that feels like it's really coming out from the side for I think the rest of us. Because when we read this, we don't hear about that detail. And I understand the logic of where you all were coming from, but I think when there is even mere like sight or evidence of something like for example, again, potentially a weapon, that even if it wasn't used in a particular way, I think that should be a detail that we should be able to decide and see from the PRR itself or what the significance of that detail was. And so I think going forward, if there are such incidents like that again, that's something that's a detail that we as a board decide is insignificant or not. Because I think from the PRR itself, we're making our decisions from that. Mm-hmm. And so it should be clear enough from the writing itself that that is the case of it. If we do think as an organization that is the case. And so I kind of want to press that on us as we move forward.
Thank you, Member Spencer. Any additional comments or questions? I think as we are, Attorney Yoon and A.D. Kiley, I do think as we move forward and we're looking at these, as much information as we possibly can get, right, to be, and not saying that you don't, but if it is something pertaining to a weapon or that could be brought up by the complainant that was not included in the PRR, that we are more sensitive to that.
I appreciate the feedback, and we're definitely going to probably do a reflection on this and think about it. Not to be defensive, because I appreciate the feedback. The thought process was, just to clarify, because the complainant wasn't aware of it, it felt a little prejudicial or inflammatory potentially. That would be the sort of, I heard about a bat, and that's it. If I was to sort of replay this for someone who's a casual observer, what would they remember about it? Maybe the bat would stand out too much in the facts, but so that was the thought process. Thank you.
Thank you. All right. We will now move on to MNCO-CC 2022-052.
All right, thank you. On September 29th, 2022, complainant submitted a complaint to the Metro Nashville Community Oversight alleging that on September 20th, 2022, a complainant was pulled over by an employee of the Metro Nashville Police Department, Officer 1, he's the only one. The complainant alleged that Officer 1 yelled and screamed threatening commands at the complainant, including, quote, "If you run, we are going to get a warrant and arrest you," end quote. It was further alleged that Officer 1 did not turn on his body-worn camera until the complainant took her phone out and started recording him. We looked at the policies pertaining to courtesy, adherence to rules, activation of body cams, and the issuance of traffic citations. The complaint also alleged that the officer had essentially overcharged and issued 3 tickets when the complainant thought there should only be 1. In terms of findings of fact, investigation found that on September 20th, 2022, at approximately 6:12 p.m., Officer 1 initiated a traffic stop of the complainant. Officer was in the passenger side seat of his patrol vehicle. He was an FTO at the time. Observed the complainant driving, turned on his blue lights, and got out of his vehicle to command the complainant to stop. When asked about the allegation that he yelled and screamed threatening commands, Officer 1 responded, quote, "I was yelling, but that was to be heard above the traffic that was outbound, and to let her know I was effectively communicating, you're the person I'm trying to pull over, come on over," end quote. Okay. When asked if he told the complainant that he would get a warrant for her arrest if she took off, the officer said, quote, "I don't know. I would have had to have known exactly who she was. For me to get a warrant for her arrest, I would have had to identify her. That would have meant me and my officer in training would have had to get out and follow her and try to ascertain who was driving the car. I only knew who she was when she gave me her license, registration, and insurance after the stop," end quote. Officer reported that at all other times during their interaction, his tone and demeanor was calm. Upon review of the body-worn camera, the first minute of the interaction is not recorded due to the 1-minute delay in audio recording being activated. While speaking to his fellow officer about his interaction with the complainant while in the patrol vehicle, the officer is heard saying, quote, "Nothing gets me more riled up, and I thought she was just going to go ahead and take off, and I was like, that's okay," end quote. During the recorded interaction with the complainant and the officer's tone and demeanor was calm. When asked about the multiple traffic tickets issued, Officer 1 stated that each was for a separate traffic offense, namely reckless driving, passing left of a double yellow line, and going through an intersection while in the center turn lane. I just want to add quickly that as to the body cam activation, the car is approaching at a healthy speed, and the officer does seem to activate that in a timely fashion when he sees the offense. So that's where the 1 minute delay comes in. In terms of discussion and analysis, from the receipt of the body-worn camera, it is apparent that the officer's body-worn camera was activated prior to the traffic stop and encounter with the complainant. The complainant alleged that the officer was yelling and screaming threatening commands, including, "If you run, we will get a warrant and arrest you." During his interview, the officer stated he did not know if he made this statement and offered reasons why making that statement would not have made sense at the time. Review of the body-worn camera does not show him making such a statement, but does not definitively resolve the allegation due to the 1 minute delay in the audio recording. The officer is heard making similar statements to his fellow officer inside of the patrol vehicle, which tends to corroborate his utterance. The statement itself is not unlawful. The complainant's allegation that officer was yelling and screaming threatening commands, the officer, when asked, stated he yelled only to make himself effectively heard above the noise of the road, which was supported by the body cam and the noise that was present there. With regard to the traffic citations, the officer offered explanations to support probable cause to issue each of the 3 separate traffic offenses. By preponderance of the evidence reviewed, the executive director concludes that the allegations of discourtesy is not sustained. The 2 allegations of violation of adherence to rules by way of issuance of traffic citations and recording are unfounded. And the executive director makes no recommended action.
All right. Questions, comments, or motion?
Move accept as presented.
A second.
All in favor? All opposed? All right. Motion is accepted. We will now move on to public comment. Ms. Callie Maxson. Ms. Maxson, you'll have 3 minutes for public comment.
Some of this may not be in perfect order here. I live on Ned Shelton Road, just 1 mile from here. You should have had access to that body cam videos. I don't know why you would not have. If it's an IT issue, that's very sad that my case was presented this way without you all having all access to the information that's in the PRR. I am a friend of the law enforcement community. I am family, a daughter, a sister of members of law enforcement. I volunteer with members of law enforcement every Sunday morning. But my experience with MMPD officers Flick and Zambrana Vera the evening of January 16th, 2022, left me feeling like I do not matter, that I am less than a resident, less than the offender of this incident. The 2 officers allowed a person to break the law more than once, commit an offense against me, all while in their presence with no consequence. They didn't care to protect my rights. Officer Flick stated twice during the incident that he would write an intimidation report for me, but he did not do so. He said this to the person he spoke to while in his squad car, which I have not been able to confirm that it was actually a supervisor or just another officer. Many things were left out of the incident report, including the word disorderly, although it was used by both officers. These officers failed in the performance of their duties and with no consequence to them as well. The COB investigator conducted my interview over the phone, a single phone call, not even virtually, but the officers were interviewed in person, possibly with human touch, the shake of a hand, with smiles, laughter, body language, pleasantries possibly, talked about maybe what they did during the summer. I do not know because I have not had access to that. I was reduced to a phone conversation, and that was 1 year ago. I never even got to meet the investigator, never got to review the evidence with the investigator, not even the body cam video or the dash cam video. I have not been given access to the investigative report or the officer interviews, nothing. But what I do have is the incident report and the body cam videos that I ordered and paid for, that I waited 90 days for and reviewed prior to the filing of a complaint. Have you seen the body cam videos? Because the looks on your face indicated that you have not seen what happened. I'm inviting anyone in this room or that's watching this live or recorded to sit down with me and to watch the body cam videos, because this is not a resolution. There are 2 incident numbers for this event, 2022-0022898 and 2022-0023003. The PRR is available online. I was given 2 days to prepare a 10-minute written statement in response to the PRR, and that statement was read to you tonight. I stand before you, sitting actually, to advocate for myself, to advocate for those who say something when they see something, and to advocate for those who report something that is encouraged on Hub Nashville, but then become the victim while the police just stand by and let it happen. Lastly, and most importantly, I would like to take this opportunity to publicly commend the officers who responded to Covenant School on March 27th. Again, I am a friend of the law enforcement community. I would like to commend the officer who I saw pull over a car that was passing others in the middle turn lane at the other end of Smith Springs Road. And when officers respond to the Nashboro Kroger, and those in the helicopter that are trying to combat street racing in this area. But I cannot commend the actions and inactions of the 2 officers that responded when I made a call for service. They were not guardians, which has been put on the police cars at the Metro Nashville Police Department. And I cannot commend the activities and actions of the COB staff in this process, and in the inaccuracies in the PRR, a report that is not representative of the incidents of January 16th, 2022.
Thank you, Ms. Maxson. Ms. Delicia, Councilmember Delicia Porterfield.
Thank you so much, Chair. First, I would like to welcome you all to District 29 and thank you all for coming out to our beautiful community center. I also wanted to congratulate Chair Haddock and thank her for stepping up. I did want to say that it is very unfortunate, the overreach and the violence that we are seeing from the state of Tennessee and their attacks on Nashville, our boards and commissions, and our constituents. But I am pleased to see who you all chose to represent you, and there is no better person that can represent you all, in my humble opinion. So thank you all for doing that. 2 really brief concerns that I wanted to uplift, and I really hope that I'm not overstepping in any way. So Attorney Yoon, please signal and let me know if I'm overstepping in any way. Member Holloway did mention a concern about a delay from MNPD with you all receiving information. If it is appropriate, I would love to have a conversation with either Director Fisher, Chair Haddock, or Attorney Yoon to hear about you all's perspective of this and to determine if there's any way that we can help facilitate a more timely process so that you all will have the information that is necessary for you all to do the jobs that you all have been placed on this board to do. So I do want to put that out there in whatever way that I can help facilitate that process. I would like to do so. With regards to the legislation that will be coming before the Metro Council, while I cannot speak on behalf of my colleagues, I will say that I know that myself and I'm sure that the Minority Caucus will do everything we can to advocate for this legislation and to advocate for the strongest version of this legislation to provide the most protection for this board. As it has been stated previously, this is what the voters wanted, and we have to uphold the will of the voters. So with that, we will definitely make sure to advocate for this legislation. And lastly, again, I don't want to overstep Attorney Yoon, so if I am overstepping in any type of way, I sincerely apologize. The person that just spoke is my constituent. The other person who was involved in this incident is also my constituent. Ned Shelton is in my district, just about 2 minutes from here. If there's no way that you could get here without coming down Ned Shelton, without passing Ned Shelton, if you came down Smith Springs Road, would it be appropriate, or is there an opportunity for you all to rescind the action that you all just did, and the board members review the body cam video, the dash cam video, and at that point possibly take another vote? And the vote may be the same, but I think it is incumbent that you all have all of the correct information. I don't know what happened, and both of these individuals are my constituents, so it is not my intent to take one person's word over another, but it is my intent to make sure that we are upholding what is right and that we're using the power that we have to do what's right. So I would appreciate if you all would consider that, and thank you for the time.
All right. Thank you, Councilmember Porterfield. Let me just say that we have entrusted our staff to do the very best job that they have been called to do when it comes to reviewing complaints and listening to constituents and community members as they bring their concerns to the Community Oversight Board. We have made sure that, no stone has been left unturned, and we have the power to investigate and go as far as our charter, as our policy allows us. But I do think that there can at times be things that are missed. And I'm not saying that we missed the boat on this one, but if at all possible, we could review this PRR again. And then if it comes up with the same conclusion, then we will take a vote on it. But if we find additional evidence that we need to review, I think it is worth looking at again. Member Goddard. Attorney Yoon.
I like to think outside the box and work on behalf of the board and what it wants to do. I also say generally we don't respond to public comment, but this is just a process question from the chair. We did make a motion. It did pass. That being said, the complainant in this case has the ability, and I would encourage her to maybe file a petition to reconsider within 10 days from this decision.
All right.
Following that, today, we will be sending this proposed resolution report recommendation to the Chief of Police and the Office of Professional Accountability. Their practice is to reinvestigate this according to their standard operating procedures. When they do so, they may come up with a completely different set of facts and recommendations than we did. That being said, when we consider the petition to reconsider, that is a chair decision, and we can make available to the chair all of the exhibits to this proposed resolution report, and she can review that on behalf of the board and make a decision whether to grant the petition to reconsider or deny the petition to reconsider, and let it be forwarded on to the police chief. So there's going to be at least 2 reviews of this if it goes through our own rules. And but there is a certain point to which our motion, which has been accepted, sort of also goes through its process. But it's not without 2 standards of review, if that makes sense.
It does. Member Goddard, that answered your question.
I did not have to file reconsideration because they were not given all the information.
So we can just initiate basically the process of what a petition reconsideration would look like by showing the chair pretty much all the information, and if the chair wishes, she can comment to the rest of the board sort of what her thoughts on that are, if that's
I'd like
the
to
wish
see
of the board.
The additional information. Thank you. Regina Morrow?
She stepped out in the hallway.
Did she? Okay, we'll come back to her. Jamel Campbell Gooch.
Thank you. First, I want to say thank you for allowing me to come and speak to you, and hello to old friends that I've done a lot of work with. Hello to current friends that I do a lot of work with in the community. First, I want to say Walter Holloway talked about it. Board member Walter Holloway talked about this board being short. As one of the original members of this board, we've always been short. And just a little history, that's because the previous city council and the previous elected officials in this city did not want this board to exist. The people brought this board about through a very difficult referendum process. So this board is not something that even our current mayor voted for when he was on city council. He actually voted against it, okay? And we fought our way to getting the COB tooth and nail. We fought for every single crumb of power that this board has. A review board, a review committee with no independent investigation power is not civilian oversight. It is not, right? And we know that the Office of Police Accountability breeds corruption. That was one reason why this board, this independent body, to investigate civilian complaints exists, because we know that corruption runs deep in Metro. So this is supposed to be a place where community members can literally come, see themselves reflected in this board, and also hear concern about what they are experiencing on the ground. So with that being said, I had a couple of suggestions, not only for you all, but for the people who fought for this board. One, make sure that every city council candidate, every candidate both in city council and the mayor's office, has a commitment to civilian oversight of police. Because without that new body's commitment, this will cease to exist. Two, demand that the current mayor and chief of police thoroughly explain to the public that they are fans of civilian oversight. I'm not talking about something that we don't understand. I'm not talking about playing political jujitsu with words. I'm talking about making very clear that in order for our people, for the people of Nashville to actually have faith in the system, we need civilian oversight, and they need to spend their social capital. Both John Drake and our current Mayor Cooper, who will also be our current mayor, need to spend their social capital making sure that this board is cemented in Nashville culture. And three, I know that this board is working with city council to make sure that you all, the current city council, that makes sure you all have some ability after July 1st. What also needs to go with that is policies to officially end the Office of Police Accountability, because it makes no sense to have two bodies doing the exact same thing. So with those three recommendations, I suggest that not only the board, but the people who fought for this, the organizations who put that petition together, the organizations that signed those things, the people who voted for it, literally start showing up, literally start fighting for power, and literally start organizing so that we can actually continuously make this thing happen. We need civilian oversight. The people have demanded for civilian oversight, and it will be the people that keep this institution in place.
All right. Thank you, Mr. Campbell Gooch. Is there anyone else who would like to offer up a public comment? All right. All right. Thank you for offering up your public comments for all those who spoke. We will now move on to new business, if there is new business. Secretary Goddard.
We had an executive committee meeting last week, and since then, I'm concerned that some of what was said there was incorrect. I had originally planned to try to have another executive session now and discuss it with the board. I think I would be better served working through the attorneys that are involved. I can't send you guys a letter. If we agree that there's some corrections need to be made, they can send one out if that works for everybody. Does that work for y'all? Okay. All right. Thank you.
All right. Any additional new business?
I have some new business.
Okay.
Just a quick ask. We have several events coming up. Last year, we participated in a lot of events in the community where we go out and put our word out in the community to let people know what services we have available, that we're here to serve, we're still taking complaints. So, just yesterday, well, Friday, I got an email, and on the 27th, which I know this is a holiday weekend, so if anybody wants to come out and with me and participate in that from 10 to 2, I will be at the Boys and Girls Club, and okay, here it is. At the Boys and Girls Club at 916 16th Avenue North. Your constituents, the people in the communities can come out and support and help us pass out information about the Community Oversight Board, and that's a resource fair at the Boys and Girls Club from 9 to 2. Then we have events. Saturday, June 17th, it will be the Music Seat of Freedom Festival, and that's at Hadley Park. The 17th also will be Black on Buchanan. That's from 12 to 7, 12 to 8, 12 to 7. And then on June 19th, Juneteenth, that's at Fort Negley. And then the Pride Fest will be June 24th. Fort Negley, that is Monday, June 19th. I'm just asking, in July 22nd, it will be the Jefferson Street Jazz and Blues Festival. And I'm just asking that everybody come out, we need volunteers, and if you want to know how to volunteer, you can just call the office at 615-880-1880, 615-880-1800, 1800, okay? And then you can also follow us on our social medias. We are on Instagram at MNCO Nashville. We're on Facebook at Metro Nashville Community Oversight. We are on Twitter at MNCO Nashville. That's my new business. This is all I have. Thank you.
Thank you, Ms. Robinson. Any additional new business or announcements? All right. If there is not anything else, do we have a motion to adjourn?
I move to adjourn.
All right, second? All right, all in favor? We are adjourned. Thank you.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.